Good morning, everyone. I see a lot of frequent flyers, so I'll dispense with the lecture about be quick, be fast, and tell us what we need to know. I'm honored today to be sitting with two of my colleagues, Judge Mariani to my right and Judge Trebilcock to my left. If you haven't appeared in front of them yet, you're in for a treat. Both are excellent additions to this court, and we're very happy to have them. That's about as much as I'm going to say. If you want to reserve some time for rebuttal, let me know. I'm the official clock keeper. That's about my only job as PJ. So with that, we'll start with item number 15, case number 364-547, People versus Allen. Good morning, Mr. Burton.
Good morning, Your Honors. Happy New Year. My name is Garrett Burton from the State Appellate Defender Office. I'm appearing on behalf of Mr. James Allen. Your Honors, this is an innocence case. Mr. Allen had an alibi, and I think the most damning pieces of evidence against him were inadmissible. And in light of that, I briefed Mr. Allen's case very thoroughly. I just want to focus on the first three issues, the alibi, the failure to investigate claim, and then the two identification claims. So I'll start with the failure to investigate claim. As you know, Mr. Allen had two trials. Before his first trial, his first attorney filed an alibi notice. That notice said that at the time of the offense, which was purported to be in Detroit, he was in Livonia with his girlfriend. That first trial ended in a mistrial, and then he was appointed a new attorney.
But was the alibi defense pursued in the first trial?
No. So Ms. Rock, who was his first attorney, didn't have the opportunity to pursue that alibi defense because the mistrial was declared before her case in chief. So I think the prosecutor was only able to call 3 or 4 witnesses before the mistrial happened. So the alibi notice nevertheless remained in the court file, and he was appointed a new attorney, and that attorney took no steps to follow up on the alibi notice.
Wasn't there some evidence that the defendant wasn't interested in pursuing the alibi or never raised it with second counsel?
I don't think there's any evidence either way in the record, Your Honor. So the second attorney testified that she had one conversation with him, and she never asked him about the alibi notice over the course of that conversation.
But she talked to him about an alibi witness, right?
No, I don't believe that that's correct, Your Honor. She never testified that she talked to him about an alibi notice. She testified that she asked him, what happened, and she got a generic, not me, wasn't there. And so, first off, that's entirely consistent with the alibi that he's raising.
Right. I guess my point is a little bit more nuanced, not specifically the notice that was filed or, the legal mechanism for presenting the alibi. But isn't there evidence that she discussed the case, and during that he didn't say, look, I didn't do it. And matter of fact, I was with Joe Smith on the other side of the state called Joe Smith. That never occurred. Defendant never raised that with her. Is that correct?
Yeah, I agree. There's no evidence that he told her about the alibi notice. Let me break that down and tell you why I think that doesn't matter.
Okay.
So first, if there's a piece of paper that says your guy is innocent, you got to ask about it. That's the number one duty that you have as an attorney. You have some obligation to either ask the client, which she never testified to doing, or ask the previous attorney or the investigator who she shared with that previous attorney or the witness themselves. There's an independent duty to investigate separate from what your client tells you. Second, we have really good reason to believe that this interaction, this meeting that she had with the client didn't happen. So the only thing—
Is that part of the record?
Yes, and I'm going to talk about it.
Okay.
So first off, she could not find Mr. Allen. That's why she had the investigator. She needed the investigator to locate him shortly before trial. Second, the attorney could not remember any specifics from this meeting that she claims she had with Mr. Allen. She couldn't remember the date, how long it lasted, what they talked about, other than this assertion that she got a generic, not there, wasn't me answer from Mr. Allen. What's more is that she told us that she keeps detailed notes from these interactions and she puts them in the court file. But when my investigator went to go pick up the court file from her, there were no notes from this meeting. So all of this in conjunction together suggests that she really wasn't talking to Mr. Allen the way that she said she did at the Ginther hearing.
And how did the trial court handle that at the Ginther hearing?
The trial courts sort of ignored that. So both ignored the whole of that. The trial court's factual findings, I think, were sort of off base. The trial court's factual findings really related to what transpired between the first attorney and the alibi witness. Now, the trial court, in my estimation, was more concerned with this idea that it seemed like the first attorney had decided not to pursue the alibi notice than what the second attorney, Ms. Manarino, decided to do. And that's not the appropriate inquiry. So the appropriate inquiry is, did the second attorney make an appropriate investigation given the evidence that was available to her? And that didn't happen.
It was, I mean, it sounds like you're insinuating that at best, trial counsel was very seriously misremembering her interactions with her client.
Yes.
And was that presented, was that attack on counsel's credibility presented at the Ginther hearing?
Yes, Your Honor. All the evidence that I've talked about came out at the Ginther hearing and was made.
But ultimately, it sounds like the trial court ultimately,
Mhm.
I understand you argue erroneously, but rejected that.
Yeah, yes, that's obviously right. That's why we're here right now. But I don't think the trial court understood the thrust of the argument, which is that,
Go ahead, finish.
Oh.
Apologize.
no, you're fine, Your Honor. Just that in order to appropriately address this claim, that the focus had to be on the second attorney and not what the first attorney decided about the credibility of the witness. Go ahead, Your Honor. I'm sorry.
I guess my question was, if I understand it correctly, the second attorney was aware of the alibi notice, testified that she was aware of the alibi notice in the first case. Defendant didn't bring up the alibi witness, didn't discuss it, didn't push it in her conversations with her. Why is that not a strategic decision by that attorney to say, look, I'm aware of it.
Mhm.
I'm aware the first attorney didn't use it.
Mhm.
My client's not really pushing for it right now.
Mhm.
I'm not going to waste time and resources chasing down
Mhm.
a witness that was never tested, never, really came forward, and my
Mhm.
client isn't pushing for it. Why is that not a strategic decision?
Yeah, I have two things. First, I actually, this is a point I wanted to make a little bit ago. It's not even clear she knew about the alibi notice. So at the Ginther hearing, when I asked her, did you know who Sinead Cannon was? Sinead Cannon is the individual who was talked about in the alibi notice. She said
To be clear that, I'm sorry to interrupt,
it's okay,
but
no
to
problem.
be clear that her relationship with the defendant was, that was his girlfriend.
Yeah,
Is that right?
his girlfriend. Yep. And I asked, did you know who that was? And she said, no, I didn't know who she was, but I knew about this alibi notice. And that there's a great deal of tension there because the alibi notice is two sentences, and one of the sentences talks about Sinead Cannon. But to answer your point more specifically, Judge, I agree it could be a reasonable decision if there was a conversation about the alibi notice. She had to take one step. Hey, what's this about? That's all she had to ask him. And if he said, I'm not interested in that, we wouldn't be here.
We're to believe that the defendant, the attorney should have done more when the defendant's girlfriend was his alibi witness and he didn't raise that with his attorney.
What I'm contending.
Yeah, that's exactly what he's arguing.
Okay. I just want to make sure I was clear.
But I want to make it very clear. The attorney only had to take one very small step, and she didn't do this. She just had to ask him, what's this alibi notice about? And she didn't do that.
Okay. Well,
I think that's.
what do we, setting aside the ineffective counsel, you raised a number of other issues.
Mhm.
Are there, help me understand, do we, any one of these, if we find in your favor, that's enough to send it back? Is that That's correct?
Yes, that's right, Your Honor.
Okay. And now you've identified the ineffective assistance of counsel and led with that. I assume that's your strongest one?
I think the alibi is really strong. I think that this is not someone I've made up, right? This is someone who, before the second trial took place, was identified and brought to the attention of the court.
Okay.
And that's why I've led with that.
Let's say we don't buy that. What's your next strongest one?
Well, the identification, Your Honor. So the identification that the boys put together. And then in concert with that is the identification of the cousin.
Well,
Yeah.
break that down for me. Is it the pre-trial identification or the ineffective assistance for not calling the identification expert, or the first time in court post identification?
So those are two
'Cause there's-
separate issues.
Yeah,
The
that's
first
why I'm
one-
asking which one's,
I'll focus on the boys and then I'll break that down for you.
okay.
So the boys' identification is inadmissible for two separate reasons. On the merits, as came out at the motion hearing, it should have been suppressed. But even if you don't think that that's enough, the affidavit that I provided from my expert explains that additional scientific information would have compelled the trial court to suppress the identification. So let me talk about the circumstances of that identification. So I want to emphasize that after the shooting took place, the complainant could not identify where the shooting happened. He gave shifting explanations for where it took place. When the police decided on one spot where this happened, they went to that spot. There was no physical evidence of a shooting. There was no blood or shell casings. They could not find a single neighbor to testify that a shooting had taken place or to tell them that a shooting had taken place. Because of this, the boy's father took this investigation into his own hands. After about a week, he landed on my client, Mr. Allen, and he tried to extort him on Facebook. Only after Mr. Allen said he was not going to pay the boy's father, did the boy's father go to the police and said, James Allen is the person who committed this crime. So that's the circumstances under which the identification takes place. The boys go there, and then the identification breaks down. So DPD has certain policies. One of them is that the identification has to be double blind. There has to be someone conducting the photo array who is unfamiliar with the suspects or the circumstances and facts of the case. That's not what happened here. This was single blind. In addition to that, the boys testified that Mr. Allen's name was attached to the photographs. This is after their dad messaged Mr. Allen on Facebook.
But wasn't the testimony that the names being attached to the photos, that wasn't shown to the witnesses until after the identification?
The boys testified at the motion hearing, conflicted that they did receive it, that it was like a cover sheet.
How do you get around the independent identification of Shamirka?
So I can talk about that if you'd like.
You have 5 minutes.
Okay. Yes, Your Honor. So once we suppress the identification from the boys, we can consider the identification of Miss Haley separately. And the prosecutor in the prosecutor's briefing does not concede, or does concede rather, that this is a first in time identification, right? So then we have to turn to what judges talked about, this independent basis. And there doesn't appear to be one. If there is an independent basis in this case, then there's an independent basis in every case, because she did not have a personal relationship with this man. She saw him for just a couple of minutes. The identification in court took place years after the shooting is alleged to have taken place.
But didn't she know him from the neighborhood?
She said she saw him one time in the neighborhood beforehand. But again, I think we have great reason to doubt that, because if that was the case, why did it take her uncle a whole week to conduct this vigilante investigation? Why didn't she tell police she knew him from the neighborhood when they came to investigate the case? Why wasn't she able to give a description of him when police talked to her immediately after the shooting? None of that happened. And all of that suggests to me that she did not know this man.
Those are great jury arguments. You got 2 minutes left.
Yes, Your Honor. The last thing I'll say with regard to the second issue is just that the prosecutor forgot to brief it. The prosecutor only addressed the ineffective assistance of counsel claim. She didn't address the identification suppression on the merits. And I don't think that she's appropriately addressed my arguments there.
Any questions?
I think anything further from me.
Judge?
No.
Thank you
Thank you.
very much. Matter is submitted.
Yes, Your Honor.
Item number 16, case number 368-260, People versus Strickland. Prosecutor is endorsed. Good to see you, Miss Blair. One of the few people from Wayne County who does their job and shows up. I appreciate it very, very much. I honestly do. So kudos to you.
Thank you.
Now you need to kick your, you know what, and you gotta kick the rest of your staff in line and tell them to be like me. So did it strike you as interesting that we have a defendant whose last name is Strickland? And the only issue here is one of ineffective assistance of counsel?
Yes.
Okay.
May it please the court, Deborah Blair, on behalf of the people, the Wayne County Prosecutor's Office, the appellee in this matter. As Your Honor said, the defendant raised one issue in the brief on appeal, which was ineffective assistance of counsel. I believe the brief fully covers that argument. I just want to inform the court that the defendant has been released from prison and has fully served her prison sentence. Other than that, I stand for questions.
Questions, counsel?
No, not from me.
Judge Trebilcock, any questions?
No questions.
Thank you very much, Ms. Blair.
Thank you.
Any questions of defense counsel?
Me.
None? That being the case, that matter will be submitted. Item number 17, case number 3666972, People of the State of Michigan versus, Utinen? I apologize.
Lieutenant,
Yes,
Utinen?
that's a good Finnish name, right?
think so.
Yeah.
Good
See, if you
morning.
were from you, blessed to be from UP, you'd know that.
I know.
Spent my freshman year at Marquette,
Ah,
Northern Michigan.
At the prison?
I used to DJ at WBKX at the college station there, and we used to get prison mail.
Oh, they were
Requesting-
listening to you, huh?
Requesting songs. It was a rock station, so they sent their requests in.
thanks.
It's Ronald Ambrose and Piran on behalf of Miss Utinen. And, getting back to the Strickland matter, I filed my brief prior to the transcript of the evidentiary hearing, or not the motion hearing being filed. So I had thought it was on time, but I was never endorsed. Just to clear the record there, but on behalf of Ms. Utinen, we also raised the one issue, and the one issue is also ineffective assistance of counsel. And we had filed that motion requesting an evidentiary hearing. We supplied the court with a couple of documents that would have established that the relationship between my client and her half sister, who was the complainant in the case, was more than the complainant wanted to lead on. The complainant in this case added my client to a piece of property that she had owned, as well as a beneficiary at a credit.
Well, you got problems with that evidence though, don't you, counselor? The victim or the alleged victim in this case testified that she put your client on her bank account as a beneficiary in the event of her death and then removed her, and also contended that the whole deed thing was as a result of being tricked by your client. So it would have caused some problems had you introduced it, don't you think?
Well, first off, she was taken off to answer the 5 credit union issue. She was only taken off after it was sometime in like December of 2019, after she had made the complaint about the credit card issue.
But there's still, I mean, being named somebody as a beneficiary, it's not like she said, oh, you get access to my account. It's if I die, you're my living relative, you're my half sister. So let's clean it up so it doesn't go through probate.
Of all the people that she could have added to that 5 account, I think it shows that there was a good relationship between the two, which and then added to that was the deed. And, you know, nobody is forcing Miss Gantz to.
Well, but I
sign
mean,
this.
when we're looking, we're not, this isn't a civil case, right? It's a criminal case. And what you're suggesting here is that counsel should have introduced this evidence. And what we're suggesting, or at least I'm suggesting is, well, had she done that, this is what might have happened and it might have backfired on her.
I think it's necessary to show that this was
And how would that have in any way proved prejudice? How would the outcome have been different here?
because it goes to Miss Gantz's credibility that my client on her own decided to open up this credit card in Miss Gantz's name. My client says that this was not done solely by her. It was done with the full consent and authorization of Miss Gantz. So I think, you know, once a jury sees that and sees this relationship of the two, I think they would look at Mrs. Gantz's testimony a little bit differently.
There was evidence at trial about past loans of money from the victim to your client, correct?
Yes. So yeah, it was somewhat, but I think this, you know, the documentation of this, these two factors, I think weighs pretty heavily. So that is the only issue that I have. If you have any questions.
Any other questions? Thank you very much, counsel. Matter is submitted. That brings us to item number 18, case number 373823, People v. Sessions. Both parties are endorsed for oral argument. Good morning.
Good morning, Your Honor. May it please the court, Jonathan Simon on behalf of Mr. Sessions as to both matters. Mr. Sessions was initially charged with, among other things, possession of methamphetamine. While that matter was pending, he failed to appear for a hearing, and he was subsequently charged with absconding. Subsequently, the two cases, the methamphetamine case and the absconding case, were consolidated. Initially, the prosecutor indicating, I'm going to look into it, I may be filing a motion. And I think actually they did file a motion, but there was no hearing on it because the defense counsel consented. There's no evidence that Mr. Sessions consented, but there was a consolidation, and both cases were tried simultaneously. We don't believe that there should have been a consolidation. We believe that it was prejudicial to Mr. Sessions. Certainly, there would have to be evidence of the methamphetamine case and the absconding case to prove that there was a case for which he failed to appear.
How does that not just end the inquiry?
Pardon me?
That admission, how does that not just end the inquiry? Wouldn't there have been evidence of one, let's assume they should have been separate. Wouldn't evidence of one be introduced in the other?
Well, yeah, there would have to be evidence of the methamphetamine case and the absconding case.
So why does that not just end the inquiry then?
Well, maybe as to the absconding case, but not as to the methamphetamine case, where it was brought. The argument is that, well, that would be coming in as consciousness of guilt. However, it was not a required element. It was nothing that had to be proven by the prosecutor. There was certainly an opportunity to present that kind of evidence in the of the absconding in the methamphetamine case, but there was no other acts, motion, or other activity generated to make that relevant to the absconding case. To the methamphetamine case. Instead, their reliance was on the fact that there had been a consolidation. And I think where the situation is that Mr. Sessions is denying he ever had possession of methamphetamine. The fact that this is brought in, it was prejudicial. And even though it may have been required in the methamphetamine evidence in the absconding case, in that absconding case, the sentence was 4 to 15. In the methamphetamine case, it was 5 to 20. So he ended up there getting 1 year more on the minimum and 5 years more on the maximum for, I think, evidence which was unduly prejudicial and should not have resulted in a combined trial. We believe, and the prosecutor, I think, included in their motion, I think, an unpublished case involving where under similar facts, there was the allowance of the consolidation. I found other cases where consolidation was found to be improper under these circumstances. And at a very, it seems as though in this case, the emphasis was more on judicial economy than on the rights of Mr. Sessions. We believe that counsel was ineffective in consenting and stipulating to the consolidation. We believe that had there been a hearing, that it would have or should have been denied. There should have been 2 separate trials. And even though there may have been the same outcome in the absconding case, we believe that the outcome in the methamphetamine case would have and should have been different. And so at least as far as that case, we believe that the matter should be reversed and remanded for a new trial.
And when you say the outcome, you mean the actual finding of guilt, not just the sentencing? Because you referenced the sentencing
Right.
earlier.
Yes, okay, no, the finding of guilt, that would be the prejudice. I mean, the prejudice, yes, that he's looking at a higher sentence, a higher minimum, higher maximum. But I don't think that that's the court's necessarily the inquiry in terms of determining whether it's a fair trial just because he got more time. I think it's what the court should be focused on is whether the trial itself was fair when the jury is not just using the absconding as evidence of consciousness of guilt, but actually it's before them for decision with respect to the merits of the case. And we believe under these circumstances that it was the counsel should not have agreed. And certainly there's no evidence that Mr. Session agreed. And we don't believe that there was a full and fair consent on his behalf and that the trial court should have perhaps done more to inquire, or maybe counsel should have done some of the cases I've cited and objected. And we believe the outcome, had he done so, would have been different.
Thank you. Good morning.
Morning, may it please the court, Brandon Ciciotti on behalf of the people. I'm here in place of my colleague, William Warden, who recently retired. So I apologize if my presence here is a bit of a surprise. I just had a couple points that I wanted to make. First of all, responding to Mr. Simon's argument regarding the consciousness of guilt evidence of the absconding. I think that clearly would have come in the possession of methamphetamine case. The Camerata Michigan Supreme Court case, which came up in briefing, I think on both sides would be on point as to that. Mr. Simon argued
So
that
the bottom line then is it didn't matter.
yes, that
Right, I mean, the alleged prejudice that defendant asserts here would have come in regardless of if it was separate trials or if they were joint, which
Yeah.
was Judge
yes,
Trudeau.
I think there are numerous bases which Mr. Warden effectively argued in his brief on which the convictions can and should be affirmed, and that would be one of them. That we would argue that joinder was permissible under the court rule. There's the one case, the unpublished case, Al Hisnawi Salman. I probably butchered that. But that was, I'd say, in all relevant manner, pretty much identical to this case. Then there was the I think Lewis case that Mr. Simon cited, also unpublished case that came to the opposite conclusion. Frankly, I think reasonable minds could differ on how to precisely interpret the core rule, but ultimately it doesn't matter for that reason. Mr. Simon said that there wasn't another X notice filed regarding the consciousness of guilt, but the obvious reason for that is because the cases were consolidated. There wasn't a need for one. If the cases were kept separate, presumably that notice would have been filed.
But counsel, why not just make the motion? You know,
Make-
like, what's the harm in just saying, hey, let's do separate trials? You know, why did council have to stipulate and just give up this potential line of defense and the advantages that Mr. Simon is arguing for?
Well, that brings up, there was one argument that I think I just wanted to add to Mr. Warden's argument in his brief, which is that for the ineffective assistance claim, there's obviously the two prongs that counsel's performance fell below the reasonable standard and then the prejudice. And I think that what might have been overlooked actually is that this might have been a strategic point on the part of defense counsel here. Especially when you look at the fact that these were both cases for the prosecution were very strong evidentially. And I think if I were actually in the defendant's position here, I might have wanted those cases consolidated. If the cases were tried separately, you have a very strong likelihood of two separate juries finding guilty on both, and it's almost certain that you're gonna be found guilty on at least one of them. If the cases get consolidated, I mean, you're throwing up a prayer, but you might get lucky and you might have a jury come back not guilty on both if you're looking for an acquittal on both. Or more likely, you might have one or two holdout jurors who might convince the rest of the jury to split the baby, so to speak, for lack of a better expression, and maybe you'll get found guilty on one, be acquitted on the other. I think that's a very reasonable strategic decision that.
One basket for all the eggs.
Correct. I think that you know, it didn't work out in this case, but I think it was a reasonable strategic decision. Any further questions?
I don't believe so. Thank you very much. And
Thank you all.
are you new to the office or?
Fairly, I've been with the Livingston County Prosecutor for just over 5 years now. I've been doing appeals, well, a little bit here and there pretty much since I started, but I really started doing them regularly for a year and a half. I know I've been in front of Judge Mariani once.
Yell at you?
No, he was very kind with me.
He's got a
It's just with
temper.
you, Judge Barella.
Oh, okay. He's got a temper.
I may have, in Judge Borello and Judge Trebilcock, I might have been in front of both of you. I can't quite recall, but anyway, it was a pleasure this morning. Thank you.
Mariani says I should retire soon, so.
I'd just like to make one point in rebuttal. I disagree with counsel's assertion that they were both strong cases. Certainly, the methamphetamine case was circumstantial, and I believe that the consolidation contributed to what was otherwise, in my opinion, not such a very strong case. So I believe that in this case, consolidation was something that was outcome determinative in terms of the allowing absconding evidence be consolidated with the methamphetamine case.
Thank you.
Thank you. Thank you both. Appreciate your submissions and arguments. Those matters will be submitted. Also, for the record, that was consolidated with case number 373824. Thank you, gentlemen. Both those matters are now submitted. Item number 19, case number 373221, Popoff versus Singh. Morning.
Morning. Morning, Your Honors. Tom Carr from Ben Johnson Law on behalf of the plaintiff, Negan Popoff. With me at counsel table is my colleague, Chris Desmond.
No, Mr. Des. We fired him a few years ago.
Your Honors, we have two issues today, duty and causation, but I think it can really be boiled down to a single issue, and that's whether the second accident involving my client was a foreseeable consequence of the first accident, which was caused by Mr. Singh, the defendant, Mr. Singh's reckless intoxicated driving. I'd like to kind of start today by stepping back and approaching this with a wide lens, the foreseeability issue with a wide lens, because I think that's how our courts have treated the issue. You know, some of the cases I cite in my brief, the Davis case, for example, court there says, it's foreseeable that if you commit the negligent act of leaving your keys in the ignition of your car, a group of minors could come along, steal it, take it for a joyride, crash it, and injure someone.
Counsel, that's because there's an ordinance passed with that specific scenario in mind. So I don't think you can extrapolate that to a general situational principle based on the analysis in the case. Am I right?
I think that's fair enough, but I do think that in the same way that there's an ordinance passed there,
You are, right?
you know, Mr. Desmond yesterday told me put that one right out front. But in the same way that there's an ordinance there, I mean, you know, we have all kinds of laws here that Mr. Singh broke, intoxicated driving.
Well, sure, but I mean, they don't directly connect to then, and then, a ordinance that was passed for the specific scenario that then actually occurred with someone, pulling over the shoulder and all that sort of stuff. I'm just saying that, Davis, has some broad language, but also has a fairly specific fact pattern as well.
Right. But I do think the broad language is great for us. I think the broad language being, remoteness, the cause and effect, the remoteness of a cause and effect should seldom, if ever, be summarily determined.
But that was 1975. I mean, you can find broad statements of principle, Moni versus Alfano, see something that says, it militates otherwise. So I don't know how much we can hang our hats on.
Fair enough.
The broad statements.
Where I was going with that is, if things like that are foreseeable, then subsequent accident here is foreseeable. And I think that notion is so intuitive that, I mean, the evidence here it really speaks to how intuitive that is. I mean, we have police statements that are replete with statements, or police reports, that are replete with statements linking the two accidents.
So that's a lot of cause and fact, right? And I don't know if that's really we have to keep good hygiene, right?
Fair enough.
Between factual cause and a legal cause. Let me ask you this. So we have Deaton and Durbeck.
Right.
If those were decided in 2014,
I think they're still irrelevant. I think they're but-for cause cases. I think they're factual cause cases, which the trial court seemingly had no trouble finding here, which
well, I guess how does that, how can that be? How can those have been decided on factual cause when those second accidents happened directly with the first accident scenes?
I have issues with the holdings, the ultimate holdings in both cases on the but-for cause issue. But I do think it's a little bit more attenuated. Say the Deaton case. The Deaton case is, guy's backing out of his driveway. Another car comes along, hits him. His passenger gets out, is inspecting the damages, seemingly kind of walking along the roadway, walking in the roadway.
By the car, yeah.
Yeah, he's by the car.
It's pinned by it's hit the car, right?
Right. The case says that he goes out, inspects the damage, he's yelling to the driver or whatever, where are the flashers? Where are the flashers? Guy says, well, hang on a second, I'll put them on in a minute. And then he walks back over there, and then he walks back to the car again, and that's when he's hit. I think.
And the driver said he couldn't see because of the headlights from the car in the first accident.
Right.
Over, right.
And I think that's kind of what makes Deaton and Durbeck a little interesting, in that the original negligence theories of driving, recklessly or negligently causing the initial accident were ultimately irrelevant because, there's alternative theories that the plaintiff could proceed on. Both cases had to do with the failure of the first driver to, whether it's, turn on flashers or turn on their headlights, that type of thing. So I think it's kind of the court there almost kind of splitting the baby a little bit and just saying,
Well,
you don't need to reach that far
you did
ahead.
Stuff that was negligent after the accident, right?
Right.
Both of those cases, they're saying, hey, there was stuff that you did after your initial negligence and causing the accident that was itself negligent. And maybe we have something there, but the first negligence in just having the accident can't sustain a claim as a matter of law.
Right. I'll say this, because this is kind of where this started with the statements in the police reports. And something I also didn't mention in my brief is that my client, Ms. Popoff, testifies that the Genesee County prosecutor reaches out to her and asks her to issue a victim impact statement with regard to Mr. Singh's ultimate intoxicated driving sentencing. So I think if the second accident was so unforeseeable, was such an unforeseeable consequence of the first accident, I don't think we have this type of evidence. I don't think we have, you know, multiple police officers saying this accident caused this accident. I don't think we have the Genesee County prosecutor evidently thinking that my client is a victim of Mr. Singh's negligence and intoxicated driving. I think that evidence speaks to foreseeability.
No, is there a line? I mean, at what point does it stop being I mean, because obviously we have these accidents. We've all been, well, hopefully we haven't been involved directly in them, but we've all certainly been stuck in the, consequences with traffic, all this sort of stuff. So, I mean, at some point there's a line here. Right. So, I mean, so tell me what your argument about where the line is here. Is there no line and it's just a jury question every time? Is there a line at some point and where is it?
I think there can be a few lines. I think one scenario is the unpublished Walcott case, which is briefed kind of fairly heavily by both sides and the trial court relied on. What you have there is essentially just traffic is backed up. That's the only thing. That's the only causal link to the initial accident. There's testimony, or I don't know if it's, I assume it's testimony, but the court's there in that opinion says neither driver involved in the second accident witnessed the first accident, nor did they even know that there was an accident scene ahead. So the
testimony from your client that at first she didn't know? She was reacting to congestion, right? That was just like, whoa, people are slamming on their brakes. I'm just going to pull over. It wasn't like, and that's my understanding. Is that not right?
She says that. And I think what you have to consider with that testimony is how fast this is unfolding. She's driving seemingly fine down southbound on I-75. People are slamming on their brakes. She doesn't know in that moment, sure. She doesn't know in that moment what is causing people to slam on their brakes. So she does what she feels is safe and leaves the roadway. She testifies, then she goes, she realizes, oh, I see, there's an accident. I think I do see how that could be somewhat problematic, but I think that would be more problematic if we didn't have the clear statements from Ms. Fox about what she was doing when she hits my client. And I think Ms. Popoff's conduct after she pulls onto the shoulder and, she's explicitly saying, I see now there's an accident. I see what is causing this congestion. I see what's causing people to get left as far away from all the commotion, the witnesses and everything on the right side of the roadway. And I'm going to sit here. I'm going to wait until my lane, the left lane, is clear enough, far enough back that I can re-enter and this hazard, slamming on the brakes, getting hit from behind.
Yeah, by her estimation, things were good, right?
Things were good. Yeah.
She was like, yeah, we're all good here. I'm ready to get back into it. And then obviously that's not what happened. So again, I guess, tracing back to Mr. Singh, if, your client's estimation was I'm free to re-enter traffic because everything looks clear and good. How does that get you closer in terms of foreseeability to the consequences of his negligence?
It's not that things are clear and good as far as first responders are gone, emergency lights are off, they're still on the scene. What she says is clear and good is her estimation of I now have enough room in the left lane that nobody in the left lane is going to slam on their brakes and hit me from behind. It's not that, this hazard is this whole accident scene, this hazardous accident scene is alleviated. It's the foreseeable. The trial court explicitly says her initial decision to leave the roadway is a foreseeable consequence of the first accident. What the trial court has trouble with is her decision, 10 minutes or whatever it is later to re-enter when she does. And then Ms. Fox.
But those two things converge.
Yeah, combining and creating a, cutting off proximate cause or causation. That kind of just begs the question, what are either of them supposed to do? I mean, if it's foreseeable that Ms. Popoff leaves the roadway, it must be foreseeable that she's going to re-enter. So seemingly the trouble is.
Well, she doesn't have to have done anything wrong for Mr. Singh to still not be legally liable for the accident that happened with her and Ms. Fox, correct? I mean, it's not like your client didn't have to have done anything wrong here for her to not still be unable to pursue legal remedy due to Mr. Singh's negligence.
Right.
Sometimes bad things happen.
Right. But I would say there's case law that says, if your negligent conduct increases the likelihood that an intervening act will occur, that intervening act is foreseeable. So I think that Ms. Fox, that clearly covers Ms. Fox. And I think that also clearly covers my client, Ms. Popoff, in that she would not, if Mr. Singh did not cause the initial accident, she would not have ever left the roadway, which it could be deemed an intervening act. Same with her re-entering the roadway. That too could be deemed an intervening act. His conduct increases the likelihood that both of those things occur. If his conduct,
Actual factors, but for cause.
well,
I think you're right. Right. But then obviously you have to take that second legal step.
it kind of it melds the two, because proximate cause or legal cause considers the foreseeability. So if it increases the likelihood that the intervening act is going to occur, and thus the intervening act is foreseeable, the intervening act is not sufficiently cut off proximate cause. I mean, if it's foreseeable that everything occurred, what is the one event, or what is, the amalgamation of events that cuts off proximate cause? Everything remains foreseeable. I guess that would be my answer, Your Honor.
Understood. Thank you, Counsel.
The only other thing that I will really want to cover that I didn't make nearly clear enough in my brief was Ms. Popoff testifies that she pulls off and she has her blinker on. She's there for 9.5 minutes. She has her blinker on for 8 of those 9.5 minutes. So it's not like, she pulls over and is just scrolling on her phone for 10 minutes waiting for all this to clear out. She pulls over, about a minute passes, she signals her blinker on, signals to other drivers that she's going to re-enter the roadway in the left lane when she feels it's safe to do so. She ultimately makes the decision that it's safe to do so, 9 minutes later. It took that long because she's effectively boxed in, because everybody's merged.
Got somebody stopped in front of her too.
Yeah. Multiple people stop. Multiple people take the same exact course of action she does. So I think the 10 minutes thing is a little bit of a red herring, and that it's not like, it's not that she just pulls over and decides, well, I'm gonna have to send it eventually. She indicates pretty clearly after pulling over that I'm not going to sit here forever. I'm going to turn my blinker on when I'm ready to go. It's clear to go. I'm going to go. So unless the court has any questions, I think I covered it all.
Nope, Judge. Okay. Thank you, counsel. Plenty of time for rebuttal. Good morning.
Good morning. Excuse me, may it please the court. My name is Tim Deemer. I'm here on behalf of the appellee, Subik Singh. I will maybe start with some of Judge Mariani's comments, starting with the Davis decision where somebody left their keys in the car, some youth took it and caused a second accident. I echo your comments of we can find language from cases from 1960, 1950 to support various things, but you're right, there was an ordinance on point there. But one other thing about the Davis case is that Davis also has language that says of all the elements of negligence, proximate cause is the one most susceptible to judgment as a matter of law. It rejects the idea that it can be a factual dispute in that case.
Oh yeah, and one way or the other, it seems like, Davis, everybody says ultimately the inquiry is reasonable minds, could they differ? And what we have opposing counsel saying is like, listen, just let a jury decide this, and why is that wrong? This is a very common lived experience for folks, every day. And why is this the sort of question that we should be taking out of their hands? When obviously we do have cause and fact. There's no doubt we would not be here if not for Mr. Singh's accident. So, why not leave this to the people who live this every day to actually handle it?
Because it's legal cause. It's ultimately a legal question, legal duty, legal cause.
But you still get to, doesn't mean it never goes to a jury. Juries get to interact with the law. evidence.
Correct. Doesn't mean it never goes, but here we don't have any dispute of facts. Everybody agrees what the facts are. The judge said there's nothing for a jury to decide on this issue. The parties agree. There was a dispute whether it was 8 minutes or 9.5 minutes between the time when which Mrs. Popoff pulled over and the other accident happened. And I think the other thing is Davis, the factual scenario there is far removed from what we're talking about here today. One accident happening, another accident happening down the road, a different period of time. So I think if Davis has language that would yield to two published Court of Appeals decisions that are directly on point, that have the same exact scenario of one accident occurring and another one occurring at a different place in a different time. So Davis might have some language about factual disputes. I agree special juries are for factual disputes, but we've got two cases that are directly on point. I don't think we should look to Davis. I don't think we should look to any other plaintiff cited Shin Ulster, a medical malpractice decision. I don't think we need to look to those cases when we have Court of
What about
Appeals.
Dylan? Guy, knocks over a stop sign almost a day later. Somebody goes through it. And how is that not, why are we not within the bounds of that one?
I'm sorry, which case was that, Your Honor?
I think it's Dillon versus Tuminga. Also a Court of Appeals decision, a little older than Deaton and Durbeck, but I don't see anything that says it's not there anymore. This is a stop sign. It got knocked over, 23 hours later. Accident happens at the intersection because guess what? People didn't stop. There's no stop sign. Question for the jury.
Well, if there's no stop sign 24 hours later as a result of this person's negligence, and no one stops at the stop, that's bound to happen that there's going to be an accident. That's completely if you don't have traffic lights, you don't have stop signs, foreseeability, yes, people are going to blow through that intersection without stopping. There's no tenuous connection there. It is direct, it is immediate, it is the proximate cause there. Our case, again, is much, much different. It's different because it wasn't a knocked out stop sign. I'm going to keep going back. It's different because we have multiple cases from this court that are directly on point involving one accident, one motor vehicle accident, and a second motor vehicle accident occurring in a different place in a different time. And when is the first accident approximate cause of the second? And I think if you look at the one case, Tanikowski was an unpublished decision. It's the one that's got the dissent from Judge Karen Fort Hood. That case had a dissent. Judge Fort Hood, in that particular case, would have held proximate cause was established, not just cause and fact. But if we look at what the circumstances of that case, it was the first accident was an SUV driving down 696, one of the busiest expressways we have in the state. The SUV flipped over in the center lane, and it's sitting there in the center lane, and the plaintiff is driving, and the plaintiff's approaching that rollover. She goes over, she merges to the right to avoid it, and then when she's merging back into the center lane, accident number 2 happens. It was the same exact location of the first accident. It was almost contemporaneous. That is a really close connection between accident 1 and accident 2. And this court still said, under Deaton and Durbeck, there's no proximate cause here for that initial accident causing the second one. That is same location, almost contemporaneous time, and it wasn't sufficient. The next point I would like to address is Deaton and Durbeck as proximate cause decisions. Plaintiff has suggested they are not, they are cause and fact, and that is not accurate. I would start with the Deaton decision and what the Deaton decision actually.
Deaton has pretty clear language on this. I think I can, Durbeck, tell me about Durbeck.
Yep, that's exactly, yeah. Deaton, really clear language. Durbeck, conflicting language. Durbeck on 2 occasions refers to there's no but-for causation, and then on 2 occasions says this is a proximate cause case.
But it talks about, this is a little outdated now, as the case law is developed, but I think it defines proximate cause as comprising the cause and fact inquiry. So I think, that part maybe partially explains, but
why they blended it together a little bit. Yeah. But even with that, Durbeck does say twice it's proximate cause. I'll quote from the opinion, page 40. quote, plaintiff appeals as on leave granted from a lower court order granting defendant's motion for partial summary disposition as to several theories of negligence on the grounds that such alleged negligence was not a proximate cause of plaintiff's personal injuries. We affirm. Again, the decision was proximate cause. They affirmed. Later, again, page 44, quote, when Royal Circuit Court Judge James J. Kelly Jr. granted defendant's motion for summary disposition, ruling that the theories of negligence alleged in paragraphs 11A through 11F were not, as a matter of law, a proximate cause of plaintiff's injuries. We agree and affirm. So there's inconsistent language, but then there's two very clear statements that this is a proximate cause appeal in Durbeck. And again, Deaton does not, I 100% agree, Your Honor, does not have that conflicting language. But then we also have, again, we have the Walcott decisions. We have other panels of this court looking at Deaton and Durbeck saying, taking these two cases together, it's a proximate cause rule of law. That's Walcott. Tanikowski is the other case that reached that same conclusion. We've cited other unpublished cases that are out there making that point very clear. Real quick rebuttal to police officers and prosecutors and what their views of this accident were. They're helpful, but it's ultimately the court's decision to decide what the law is. We don't outsource decision-making to police officers, expert witnesses, and the like. Let me see. I'm comfortable with Deaton and Durbeck, the presentation on those 2 points. On the duty question, that's alternate grounds. We'll just rest on the briefs there. But I do want to talk about maybe a bigger picture. I know Mr. Carr started from a wider lens. I'd like to conclude on a wider lens about the pre-November 1, 1990 rule we have in the court rules. It's this odd scenario where this panel might not be bound by a pre-1990 decision, but trial courts are. That's the situation we have. That's the way the
Well,
court
the case also says that, we're not strictly bound, but they have precedential value,
Correct. Exactly. And I would urge the panel to just in an unpublished opinion, affirm the summary disposition ruling. I believe Durbeck and Deaton are good, solid rules of law. They're consistent with Michigan jurisprudence. And the facts of this case would make it a bad candidate to overturn those two decisions. And again, time is not a red herring. I believe that is what plaintiff's counsel had to say. Time is something that the court is supposed to consider when looking at proximate cause. That's actually one of the factors that's cited. You look at the connection between the incident and the injury. One of the factors we look at for proximate cause is the amount of time between the two events. And here we have 10 minutes. Tanikowski, we had virtually simultaneous, was not enough. But this court in a case called Woodring versus Phoenix Insurance, it's 325 Mishap 108, 2018 published decision, confronted a situation where we had a confused state of the law because we had pre-1990 decisions, and then we had subsequent unpublished decisions disagreeing with the published case. And then the panel in the Woodring case also had a peremptory order from the Supreme Court to address. And Judge Running Krause, wrote this really long opinion addressing the principles of stare decisis and what's the value of a published opinion pre-1990 when you compare it to an unpublished case and you have intervening change from the Michigan Supreme Court. And it was a confused mess. And the panel really struggled with how to identify what the controlling law is. And the panel came to the conclusion awfully similar to what Your Honor said. Although we're not 100% strictly bound to follow, it has precedential value. And Deaton is not an outlier. It's not one case from 50 years ago we're relying on. There's Deaton, there's Durbeck, and there's multiple panels of the Court of Appeals following those decisions saying it's proximate cause question. That the second accident is not a proximate cause. I'm sorry, the first accident is not the proximate cause of the second accident. We have multiple panels. We have one dissenting vote in a much different case. Again, that rollover on 986. So again, I would urge the panel to affirm unpublished opinion. I don't think this one would warrant a conflict panel of the Supreme Court getting involved. This panel has any questions?
Nothing more from me.
Questions? Thank you, counsel.
Thank you.
Rebuttal?
Just a few points, so I'll be brief. I'm not going to make a big deal about the pre-1990. It was like half a sentence in my brief. I don't really have much of an opinion on that one way or the other.
Well, in fairness to you and other lawyers, this court has kind of mucked that issue, not a little, quite a bit. But essentially where we seem to be landing now is unless it's been reversed or there's been case law, it's still good law and we still follow it.
I think that's fair enough. On Dean and Durbeck, I think what those cases do not establish is that there is a hard line rule that as a matter of law, one accident can't cause another. I think you have to weigh the various circumstances, the various factors which contribute to an eventual accident. And that's ultimately what Deaton and Durbeck do, and they come to an ultimate conclusion, but it's not like they're establishing, this is a hard and fast proximate cause rule. I agree that Deaton is a little bit vaguer on whether it's a factual cause or a legal cause case. I think Durbeck is very clear. I mean, and Judge Mariani, I think you're exactly right about everything Mr. Deemer said about of quotes about proximate cause. That's because in a lot of cases, older cases, they say proximate cause is made up of but-for cause and proximate cause.
Yeah,
So
the folks upstairs have been trying to clean that up.
right. So what it's talking about is causation in general. I mean, this is a quote, page 46. In the instant case, defendant alleges that the specific acts of negligence asserted in paragraphs 11A through 11F were not a cause in fact of plaintiff's injuries. We agree. I think it's very clear. The Tanikowski case, Mr. Deemer said, he made some allusions to it happens at the same location. This accident does too. And that's why, and it's referenced in Ms. Popoff's deposition testimony. That's why the entire accident is captured on 2 police officers' dash cams, because the subsequent accident takes place in the heart of the initial accident scene. And also on Tanikowski, I include a long block quote in my reply brief that kind of emphasizes how unforeseeable that plaintiff's conduct was. I mean, he says he's tired. He wants to get home. So he decides to weave through an entire active accident scene. Of course, says rather than stopping his vehicle, which is the action Ms. Popoff took here, that's what he chose to do, which was ultimately unforeseeable. I think that's
I'm sorry. Go ahead.
No, I was just going to say, I think that's all I had.
Question?
I think there's fact questions here and it's
Show nothing further from me.
Thank you, counsel.
Thank you.
Mr. Desmond, how long has it been since you worked here? It's gotta be.
It has been almost 1 week.
Wow, I never would have guessed that.
I left, because I left, my son was just turned 1 year old.
Oh, my goodness, wow.
So, yeah. Trusting other people and everything.
I'm telling you, Mr. Desmond was Judge Stevens' law clerk and a very highly respected member of our staff and has done very well. Thank you. Thank you. Matter is submitted. I appreciate the effort of counsel and the arguments in assisting us to make a decision. It's a difficult case and hopefully we'll have a decision for you shortly. Thank you all very much. You don't need to go anywhere, right? Item number 20, case number 370744, Cater versus Powell.
Good morning, Jason Blankenship on behalf of Mr. Cater.
I'm sorry, your name again?
Blankenship, Jason Blankenship.
Oh, I'm sorry. Yeah, there you are. You're on.
Yeah, I was like, oh, well, I should be there.
Yes, you are.
All right, excellent. I'll be very brief because I had a lot more to say when I initially filed the appeal, but obviously the case versus Citizens has resolved itself. And that was really much more contentious. But here, the only thing that we have to talk about is the language drafted by Cure and submitted to its customers. The exclusion for uninsured motorists is they don't provide uninsured motorist coverage for bodily injury sustained by any insured, defined as a person occupying a covered auto, who is using a vehicle without a reasonable belief that the insured is entitled to do so. The distinction here in these facts versus Huggins, which obviously is the case relied upon by defense counsel, is that while regrettably, Mr. Cater did not have a license, he was certainly old enough do so. And he had been entitled by his girlfriend to drive the car pretty much,
That's not going to help him if he gets stopped, though. Well, not all the way, at least, right?
not all the way, certainly, but he's, he was entitled as had a reasonable belief from his girlfriend that he was entitled to use the vehicle.
He was allowed to be in the car, but there's no argument he somehow reasonably believed that he was a licensed driver.
If only. This would be, I feel a lot better about my position.
Not sure what that would look like, but yeah.
Yeah. And nor I, but other than that, unless the panel has any questions, rely on the briefs.
Questions? No, I don't believe so. Thank you very much.
Thank you.
Still morning. Good morning again, Your Honors. Tim Dean on behalf of the appellee here, maybe after the appellee cure. I will also be very brief. Unlike the case of Popoff versus Singh, here the controlling court of appeals decision is after the magic cutoff of November 1, 1990.
98, right?
Yeah, we got a full 8 years of wiggle room there to be precedentially binding. Huggins very clearly said permission is one thing, entitlement is something different. Permission, especially in the context of auto cases, has a very clear meaning. We have permissive user, owner liability statute, those kinds of things. Permission to drive is one thing, entitlement is another. Mr. Cater was not entitled to operate this vehicle or any vehicle on a public highway because he was unlicensed. And I will just address the distinction Mr. Blankenship drew between the individual in Huggins who was 13 years old and Mr. Cater who was an adult. That's a distinction without a difference. Mr. Cater may have been over the age of 16, but he didn't have a license. He never had a license. It's not like it was suspended or he had a license in another state and didn't renew it. He never had a license, driver's license. He never took driver's training. He's functionally the same as a young child who's got no driver's license under the law. Huggins has been applied in context in other cases of this court, other cases around the country. The Northern District of Georgia looked to Huggins to decide the issue of Michigan law and applied it exactly as Cure has asserted should be applied here. I have nothing further. I'm happy to answer a question the panel might have.
I don't think so. Any rebuttal, sir? Thank you both very much. The matter is submitted. Before we get into the 11 o'clock, we're going to take a brief recess. Court will be adjourned.
All right.
Good afternoon, everyone. Thank you, or good morning, Stowe. Thank you for letting us take a break. I know it seems selfish for us to do that, but trust me, you do not want to be in front of us when we go straight through. Tempers get short. It helps us, we're hearing all of these different cases and lawyers are very good at what they do and it gives us a lot to think about. So I appreciate, having a few minutes to just kind of regroup and get ready. That being said, we'll move on to item number 22, case number 372-998, Collins versus Anderson Forklift. How are you today, counsel?
Your Honors, good. Thank you. Ellen Schrader on behalf of the plaintiff. This is a case where a forklift tire split apart and my client was injured and never returned to work since October 23 of 19. In writing, defendant Superior Tire agreed that the tire had failed, that it honored the tire's warranty and ordered that the tire be destroyed. There was a fourth amended complaint in 2020. It was very difficult that year to get records and determine what had actually happened. And that fourth amended complaint was filed on December 21 of 2020, adding Superior Tire. And Superior Tire was served by regular and certified mail. The regular mail was not returned. The certified mail was signed on December 29, 2020.
You concede though that was signed by not any of the individuals listed in the court rules. Would you concede that point?
Well, there was no registered agent in Pennsylvania, so we just addressed it to the company.
Right, but there's a list in 2.105 D2 of, director, officer, et cetera. And would you concede that none of those individuals signed for the document? Do you have any evidence that any of those individuals received a copy of the lawsuit?
I do not have evidence of who Thomas Westfall is. The defendant says he was a high-low driver, but I know that Thomas Westfall signed for this mail and signed for other mail subsequent to that.
There's Thomas Westfall, director, officer, et cetera. There's public records of who are officers and directors of companies, right?
The defendant does not say that he is a director, and I've had no discovery from Superior as to who Thomas Westfall is. I did ask to be allowed to take his deposition, and that is also part of this appeal.
Right.
But it's clear that defendant Superior received the summons and complaint in a timely manner. MCR 2.105 K3 says an action shall not be dismissed for improper service of process unless the service failed to inform the defendant of the action within the time provided in the rules for service. The defendant was informed of this action timely.
But Mr. Westfall was, or I guess how do I know that?
Well, there's regular mail and there's certified mail. The regular mail wasn't returned. It was all to the correct address. It was sent to the correct address, regular and certified mail, and they received it.
Well, who received it?
I get mail.
Who do we know?
I get mail in my house all the time, and we get mail all the time, and there may be a month that it gets buried under somebody else's stuff in the kitchen, and I don't know of it. So how do we know an officer or director or somebody responsible was aware that that piece of mail came in?
Well, I asked to be allowed to take his deposition to see what did he do with the summons and complaint after he signed for it, and what did he do with the other mail that he signed for. But he was obviously in the office at defendant Superior Tire, and he had authority to receive mail. He signed for it on more than one occasion. We know
the court rule's pretty explicit about the individuals for a corporation who have to be served.
Well, the court rule, I'm not denying that, but the court rule also says that if the defendant received the complaint in a timely manner, that the action shall not be dismissed, and that's mandatory. That's not discretionary.
I guess it sounds like we have evidence that Mr. Westfall received the complaint.
Yes.
For better, or for worse, he decided to sign for it.
Yes, at Superior's office.
But I guess, so what tells me that for purposes of this court rule, that is adequate to say that the defendant had actual notice? That you had, somebody at the office who said, I'll sign for it, and did it, even if he didn't necessarily have authority to do it. How do I know that provides actual notice to the defendant, Superior Tire? Is there case law that helps me with that? What gets me there?
Well, all the cases that we analyzed, where the case was not dismissed, such as Walker, it was just sent by first-class mail. It wasn't even sent certified mail. In the Morden's case, it said if there's a question of fact as to whether the defendant was served and received timely notice, then you're allowed to have discovery on that fact. And that's why I asked to take the deposition of Mr. Westfall to see what he did with the summons and complaint.
So which case is that? Is that
Morden?
So Morden affirmatively speaks to discovery.
Yes. It says if there's a question of fact as to whether the defendant received timely notice, there should be discovery allowed. It was an unpublished case of the Court of Appeals. Most of the cases on this subject are unpublished.
Is that a decision that the trial court, having the benefit of all the evidence and the testimony in the first case, it's their discretion? And are we reviewing the discovery piece for an abuse of discretion? Or do we review this issue on having discovery regarding this service thing de novo?
I think you should review it de novo because there was no discovery. No discovery was had. There was a motion for summary disposition in lieu of an answer. So there was not an answer and there was no discovery of anyone at Superior.
Right, but the court's decision to deny your motion to compel the testimony of the guy who signed for it, isn't that an abuse of discretion for us to, don't we review that for an abuse of discretion?
I think it was an abuse of discretion.
And do you have any case law that under similar facts where a panel of this court, published or unpublished, found that it was an abuse of discretion in circumstances such as this?
Well, the Morden case is the only one that considered if there's a question of fact as to whether there is a timely notice that it was timely received, then their discovery is appropriate. We know that this is a person in the office. Now, maybe it was a person, a homeless person who wandered in and didn't ever do anything with the mail, but we know that he repeatedly signed for certified mail.
Yeah, and it doesn't, I don't think opposing counsel disputes that this was an employee.
Yes.
Right.
Correct.
Yeah,
So
so we
yes.
know there's a relationship.
And whether he threw this summons and complaint away, it seems very unlikely in a business that is open. And some of the other cases, the businesses had been closed and service was made. But here, this is an active business. They were served with regular and certified mail. Letters were sent at least 7 other times by email, by certified mail, by fax, asking why. Here's all the proof that the tire failed. You honored the warranty. The tire was ordered destroyed by you. It was addressed to another person, Keith Birch, director of EHS. That was his title. And he received certified letters, faxes, emails. Why don't you respond to this? This company received a tremendous amount of letters, and we know they actually received the summons and complaint. I waited a lengthy time to take their default, asking them why they didn't answer. And then 7 months later, when after I give them the default judgment, and 7 months later, they bring a motion to set aside the default, they don't use the affidavit of Thomas Westfall. They don't use the affidavit of Keith Birch. Another certified mail was received by Will Roberts. None of those people did affidavits as to why the motion should be set aside and how they didn't actually receive notice. They did actually receive the summons and complaint. And those people should be allowed to have, we should be able to find out what they did with the summons and complaint when they actually received it.
So your entire case rises and falls on if the signature of an employee of a company is sufficient to establish actual notice. If I understand your argument correctly, that if I send a complaint to any corporation and somebody signs for it and I get it back, that's sufficient to establish notice. I've met my burden as a person to say I've effectuated service. That's enough. Any signature.
Yes, a signature of the business person who's receiving the mail shows that it was received by them.
So any employee that signs for the mail, that's sufficient. But the court rules don't say that. They list explicit people.
But the court rule does say, even if the service was improper, an action shall not be dismissed
But counsel,
if they received it.
If you take that to the extreme, though, we're basically just eliminating that list. You know, if you say like, here's a specified list of people you have to serve. But if somebody else signs for it because of this other rule, that list doesn't matter. There has to be some limit to that principle. Like when we say about the defendant having actual notice, for that other court rule to still have some life. in some practical meaning,
The
right?
court rule only comes into effect if service was improper.
But if it's going to make the improper surface proper every time
So
because somebody
it-
else signed, I'm sorry. Go
No,
ahead.
no, go ahead. Finish your thought.
That's,
That, now that I interrupted him, he forgot his thought. You're
oh,
welcome.
it's still there.
You're welcome.
It's festering.
I guess what would you concede then that service wasn't proper? And the only way,
Court of
that-
Appeals told me that the service was improper.
right? So you concede service was improper.
Well, I don't, but the Court of Appeals told me that it was. So that's why this court rule comes into effect.
Okay.
Even if
So
the
what
service is
evidence, let me
improper.
just pause you for a second. Beyond the signature of an employee that you say has signed for other mail, what other evidence can you point us to that defendant had actual notice of the lawsuit?
I sent them 7 letters, and I sent the letters by email, by fax, by their email, because they corresponded back to me. I had their email. I addressed them to Keith Birch, Director of HR/EHS. Why aren't you responding to this? I took your default. The complaint has been served by you. We took your default. Now we're taking a motion for default judgment. That was sent again by email, regular certified mail. They had notice before and
What were-
after the service.
And forgive me if I just don't have it at my fingertips. What were the responses from that individual?
He responded before the service, before the complaint, saying we're not responsible for this.
But so
Then
before you
after
filed
that-
the complaint,
Yes,
he responded to your emails?
yes.
Okay.
And then I sent him letters confirming our prior
But did he,
communications. The
but did he,
complaint was default.
I guess what I'm saying is you filed the complaint, you mailed it. You got a notice of default because they didn't answer. And you're saying after that, you emailed them again.
Oh, yes, repeatedly.
And what were the responses to those repeated emails?
No responses.
Okay, so again, that leaves me with maybe he's out on medical leave, maybe he's, how do we know what is the evidence besides you sending an email to an email address that previously had responses, that after serving the complaint, there was responses and notice by the company or director?
Because I used the fax number that was on the stationery of Superior. I used the email that was on the stationery. I used the address that was on the stationery. And I think there were 14 times I sent communications to them besides the summons and complaint, which were signed for. We know that Superior received the summons and complaint, and the court rule says when service is not proper, an action shall not be dismissed unless the service failed to inform the defendant of the action within the time provided in these rules for service. And it did. They received the summons and complaint timely, plus a lot of other communications. And that's why the trial judge wouldn't set it aside, because I had sent them so many communications. And we have proper service with a signed certified card signed by an employee who had received mail for the defendant on other occasions. So I respectfully ask that you send this case back to the trial court so that we can find out some of the facts here, because there has been no discovery in this case of Superior. Thank you.
Good morning. Veronica Prang, appearing on behalf of Superior Tire.
Your name again? I'm sorry.
Yes, Veronica Prang.
Veronica.
And then my last name, it's P as in Paul, R, A as in Apple, N as in Nancy, G as in Go, E as in Ed. I have to do this pretty often.
Well, you're not on the list. That's why I asked.
Yeah, my appearance was only filed Monday.
Oh, Oh, I apologize.
They
You're
stuck
on
me
the-
in right at the end.
Gotcha. Can I ask a real quick question before you start in?
Absolutely.
Sorry, this case was heard by this court before, correct?
Correct.
Why is our finding in that case relative to service of process not binding?
I mean, it is technically, I mean, it is an unpublished case. I will concede that. I don't agree that it's not binding. It is the law of the case. We
Why
got,
are we discussing it a second time? That's my question. If it's the law of the case, regardless of if it's published or not, it dealt with the same parties and the exact same issue. So why are we here again? Is my question.
actual notice. That is the
So this is a separate issue.
correct.
Okay.
This centers on
I
actual
just wanted
notice,
to clear that up from the get-go.
which was not addressed in the original opinion. So, yeah, absolutely. So I do want to address a few things at the outset that council indicated. So for 2.105 K3 to apply, there has to be for K3 cannot apply if there is a complete failure of service. That's what we have here.
How's this complete failure? This feels like a failure in manner.
It's complete failure because, well, no attempt at personal service, complete failure for that alone. But in addition to that, the person who signed for this letter is not a person listed in the court rule indicating that they can accept service on behalf of this corporation, and that is Thomas Westfall.
But this isn't a case where they just didn't, it's sometimes hard to draw the line between complete failure and failure in manner or content, right? And, this isn't a case where they just didn't put the documents out into the world, right? And make some effort to serve a proper party. Those documents were put out there, but obviously there were deficiencies. We know that from the first time around. So I guess how are we, what case can I look at that says, that tells me this is a complete failure?
That would be Tucker. I can get you the site in a minute.
If it's in the briefing, that's fine.
It is in the briefing, yes,
Okay,
Tucker.
Tucker.
Specifically
You think that's
says,
the best one?
yes, and we did set that in our brief. Complete failure of service is indicates that K3, not indicates, K3 is inapplicable, meaning the
I understand the principle, but I mean, what do you have case law that tells me that these facts constitute complete failure? Is that Tucker too, or no?
yes, that is Tucker as well. I think, not I think. The complete failure also comes from the fact that there is no proof in this case that the fourth amended complaint was served on anyone at Superior Tire, let alone Thomas Westfall. Their letter indicates that it was just a summons and complaint. We were not a party until the fourth amended complaint. And that matters for the fact that if we didn't even have we didn't have the fourth amended summons or the fourth amended complaint, how could we possibly have been put on notice of a lawsuit being filed against us, right? So that is one of the main factors why this is a complete failure.
So, counsel, along the lines, how do you rebut plaintiff's argument that says, look, well, let me start with one question. Do you agree or concede that an employee of your client signed for the original summons and the original complaint?
I don't think, would I concede that? So that is correct. An
He
employee.
signed for, and it's an original summons and the original complaint.
We have a letter indicating that that was enclosed.
And so that was acknowledged. Well, how do you then rebut plaintiff's argument that after that, they mailed and emailed and faxed to all the publicly listed numbers and addresses, or presumably on a, some corporate Pennsylvania corporate law or website, right? That they faxed notice of default entry of default judgment. Here are the copies of the complaints and kept emailing. Are you arguing that if a company doesn't acknowledge, they can just ignore all that? And until somebody traps them in the parking lot and hands them a document, there's no notice? Is that the argument?
No, it's not. Our position is none of those correspondence matter because they were sent after the date that the summons expired. They were not provided within the time frame, and K3 specifically indicates that service has to be, even if there's a technical deficiency in service, it has to still be quote unquote timely, right? And none of those correspondence were sent to us during that time frame. And in addition to that, the pleadings weren't attached to those second, there was no summons, no complaint sent with any of those additional correspondence. And I thank you for asking that question, Your Honor. I do want to reorient the panel to the fact that we are only talking about the time frame in which the summons had not yet expired. The summons was issued on December 22nd, 2020, and it expired on March 22nd, 2021.
And just so I'm clear, this is the summons for the
Fourth amended complaint.
Fourth amended complaint.
That is correct.
So there's 4 summonses that were issued.
That's correct.
That's
Summonses,
correct.
yes,
So
I think that's the
I'm
plural.
looking to you.
Correct.
Okay, thank you.
Yes, so it was the fourth amended complaint. And again, that time frame, right? There is one letter that was sent, certified mail only, no attempt at personal service. Tucker stands for the proposition that no attempt at personal service is a complete failure of service. That's a direct quote. And again, I can look back in I would have to find the reference. Needless to say, this letter sent certified mail only, signed for by an employee, but an employee that did not have the authority to accept service on behalf of this corporation. And, counsel indicated that there was no information about who this person is, and that's not true. Our affidavit from the CEO of the company indicates specifically that this person was a maintenance person. He signed for it, and there's a potential explanation for that, Your Honors. Horton v. Chase indicates that mail sent to a PO box also is insufficient for K3 to apply. This correspondence sent December, I think it was 22nd, 2020 by plaintiff was sent to a PO box for the corporation. It wasn't directed to any one specific, it wasn't directed to anyone, let alone a officer, a person in charge of the business, anything. It went to a PO box. And again, Horton v. Chase indicates that that is insufficient for purposes of K3 to apply.
So just so I'm keeping track. So opposing counsel said that we mailed this to a certified mail and regular mail, right? So are you saying the regular mail was to a PO box?
Correct.
Okay, and the certified mail was to whom?
It was not addressed to anyone. It was also sent to a PO box.
Okay, got it. So you're both sent to a PO box, and the content of what was in that mailing was what? Is that in dispute, or do we know that?
It is in dispute to some extent.
What's not disputed about it?
It's not disputed that the correspondence sent says only that the summons and complaint are attached. It doesn't say fourth amended complaint, etc.
So there's a letter in the envelope, trying to be very tangible here. There's a letter in the envelope that says what?
Enclosed, please find a summons and complaint.
Summons and complaint.
Correct.
Okay, and then what do we know after that? What else is in the envelope?
Counsel provided an affidavit from their legal assistant saying that they enclosed the summons, the fourth amended complaint and fourth amended summons, right? We would argue that that affidavit is inadmissible because it lacks foundation. This person apparently reviewed internal documentation.
Doesn't have personal knowledge. Didn't stuff the envelope.
Correct. In addition to that, it shouldn't be considered because it wasn't timely filed with their reply brief. I think I've answered your question, Your Honor. What was contained in this correspondence? Based on the correspondence alone, it indicates the summons and complaint. It does not say fourth amended, anything like that. This affidavit was only provided, I think, a year after these issues came into dispute. And we would argue that it is not proof that the fourth amended complaint was actually delivered, accepted by Thomas Westfall.
Now, let me ask you, so I understand all of those arguments. Let's assume that it was. Let's assume that this letter, different case. Let's assume no dispute, certified mail, had the right complaint, the fourth amendment complaint, summons, and Mr. Westfall signs for it. Still defective service. But we're still in the argument of like, well, actual notice. Here, the trial court, did not allow a deposition of Mr. Westfall to say, hey, what did you do with that thing after you signed it? And I guess I'm wondering, presumably you think that's the right decision. I guess I'd want to know why. And then also, how else are they supposed? That seems, seems like something you'd want to know, right? What did this guy do with this important mailing? And how, if it's not through a deposition in this circumstance, how do you ever fill that gap?
So I guess I'll start by saying that I want to reiterate that assuming exclusively based on what you just said, that Thomas Westfall did sign for the fourth amendment complaint, it does not matter because he was not designated as someone to accept service, right?
Proper service, right?
Correct. But
then we're trying to figure out actual notice, right? Because it can, if he signed for it and then, gave it to the right folks, then it seems like we're within the right amount of time, and it seems like we're in the K3 territory, maybe, So how do we figure out whether that happened? I mean, I know your client says no, but presumably there has to be more than that.
I would say it is plaintiff's burden to prove that. I understand that
They're trying to, right? They're like, yeah, we want to talk to the guy to see what he did with it.
So I guess I'll start by saying procedurally, pursuant to the prior opinion of this honorable court, they never got personal jurisdiction over Superior Tire, right? So they're not entitled to the deposition. I understand they want it. I understand maybe we want this information. We have an affidavit from the CEO of the CEO of the corporation indicating who this person is and the fact that it did not get to anyone with authority to accept service. Therefore, they didn't have the people who had that authority did not have knowledge and therefore weren't put on actual notice of this.
But you see the issue here, though, right? You're on the one hand, you're saying they have the burden, and on the other hand, you're saying only we can put in an affidavit. So unless your client just admits it, how do they carry their burden?
Presumably, Your Honor, through the appropriate means of service, meaning.
Well, yeah, I mean, we know that's not the space for it, right? Obviously, if they did, if we don't have the hair, we aren't here in the first place, and that's a fair enough point. But
I would just say, let me try to help you out. You said that all the communications plans council cited the emails to the HR director, the faxes, all of that occurred after the summons. Every one of those?
There were emails from that HR director prior to the fourth amended complaint even being filed. There were two correspondents that were sent to the office. They were received and responded to via email, and they were just requests for information.
So let me just break that down for a second. So complaint gets filed, original complaint gets mailed. Okay, correct me.
No, there were no pleadings sent in the two original letters that were sent to Superior Tire. It was exclusively two correspondents asking for information. A plaintiff was asking Superior Tire to admit that they had liability for the circumstances of Mr.
But so Fourth Amendment complaint. Did any of the prior complaints, original through third, also get mailed and signed for?
No,
And the fourth was the first one that Superior Tire was included in?
correct.
Okay. First one they're included in. After it was mailed and signed for, were there other additional communications between that date and the summons expiring with Superior? The HR director, the faxes, the letters, whatever, the laundry list of things plaintiff's counsel cited.
No, the next correspondence that was sent was in June of 2021. So well after the summons had already expired.
Gotcha.
There were no additional attempts after this initial letter, and was sent on in December of 2020. So, I mean,
So you would say, well, let me ask you this, would you concede that, let's say those communications had been sent after or prior to the summons expiring of the Fourth Amendment complaint? Is that enough for plaintiff to have an opportunity to meet their burden, that actual notice that says, look, I sent it to, we had been communicating with the HR director, I mailed it, maintenance worker signed for it, and after that, prior to the summons expiring, I emailed copies of it and corresponded and sent emails to the HR director who I'd been communicating with before, prior to the summons expiring. The guy just ignored it. Is that enough to show actual notice?
no, it's not, particularly if it went to the HR director, because a person with the authority to receive service has to be made aware of, right? That there is a complaint. And the whole purpose, right, behind service rules in general and this circumstance is due process, right? The opportunity to be heard in a court of law, and to be on notice of a lawsuit against this corporation. And even if emails, faxes went to Westfall and he sent it to HR, still not actual notice, not anyone with authority, right?
If he sent it to somebody with authority.
So only if they had an opportunity to appear in court, meaning, the case law that we rely on consistently indicates that it is that K3 can apply in a circumstance where an individual with knowledge, an individual with authority to accept service with knowledge of these circumstances, who then passes it along to someone who then appears in court or acknowledges the lawsuit. That is sufficient for K3 to apply, because in that circumstance, they have the opportunity to appear and be heard in court. Their due process rights are not being violated.
So I guess if Mr. Westfall signed this, and if he gave it to somebody within the time of the summons that should have gotten it in the first place under the court rules, would that satisfy K3? Because all we have there is, it didn't go just as it should have, but it made it to the right person in the right amount of time. Isn't that the sort of thing that K3 is designed to address?
If they had the opportunity to appear, but I think what you're getting at, Your Honor, is whether or not, it's important for them to obtain Mr. Westfall's deposition. Mr. Westfall's deposition does not matter. He is not a person with authority to receive service. And to whatever happened with these pleadings in between, they did not get to the people that they needed to get to with the authority and to ensure that Superior Tire's due process rights were not violated.
But how do we know? I mean, we have the affidavit from your client saying we didn't get it. But I guess I'm trying to figure out, how do you build the record around that? Presumably the rule isn't just we have to take your client's word for it necessarily. There's you saying we never got it, but if the person who had it says I gave it to you, right, then there's a dispute. But how do we know if there's a dispute?
We have no information about that. I will concede it, but again, I don't think Thomas Westfall's deposition is not important. It's not necessary because he was not somebody with authority. It did not get to somebody with authority. I understand that there is there is some sort of, actually, no, I don't even say that. At the end of the day, what's important is that Mr. Westfall did not have actual authority to receive service. And to the extent that whatever he did with the complaint, it did not get to the right people. And that is why there is no actual notice and therefore K3 cannot apply. I think it's also important to point out that
Is there anything left to point out that we haven't already covered candidly? Do you have any more questions?
No, I think I've,
Judge Jabilcock, any more questions? I think we understand your position. Is there anything further you'd like to tell us?
I guess I just want to point the court to Evan v. Gross, which indicates that even an individual with the right to sign for mail, it's insufficient for K3 to apply.
Thank you, counsel.
Thank you.
that's in your brief, counsel.
It is correct.
Rebuttal.
The Tucker case, I didn't get the name of the case that defense counsel just cited now. Did you say Ebony?
Evans v. Gross.
Evans v. Gross. Okay, the Tucker case was decided in 1986, and it is a Michigan Supreme Court case. The 105K3 was passed in 1985. I mean, it was made a court rule in 1985. The Tucker case never discussed 105, which was then J3, but whatever happened in the Tucker case happened before that court rule. In addition to the summons and complaint, now my exhibit L to our appendix is the letter that Superior Tire was sent, September 22, 2020. And it's sent to Superior Tire and Rubber Company, 40 Scientific Road, Post Office Box 308, Warren, Pennsylvania, with the zip code. It has an address and it has a post office box. If it was delivered to a post office box, there would not be a signature on this card. This was delivered to Superior and signed for by their employee. After the summons and complaint was sent to Superior Tire and signed for, then within the time of the summons, we took a default in February. Even though they signed for this in December, we took their default in February and sent them the default as well. And that's one of the exhibits here as well.
Counsel,
Go ahead.
all right, counsel, isn't the best evidence that there was no actual notice to the company is that they let a default get entered against them?
They were
that's
ignoring
occurred
the
after
service.
after you mailed it. You sent emails to them beforehand. You got responses back from the HR director. They denied liability. They were responsive.
One response was received from,
Okay,
yes,
they responded.
before, yes.
And then you send this letter, you send a complaint to them at some point later with the Fourth Amendment complaint. You add them as a defendant. And they don't answer. They don't show up in court. They don't send you a letter. You get no email from the HR director. You get nothing. And you get a notice of default entered. Isn't that evidence that no notice was received?
No, it's not. Because it's signed for by an employee of the company to whom it's addressed. And
aren't you asking us to speculate or to say, you know what, it's enough. You just mail it to somebody. I show that I mail it. And aren't you asking us to say, okay, that's enough. If you can show that some person signed after it was mailed to the location, that's enough to conduct discovery. Isn't that what you're
an
asking us to say?
employee of the defendant signed that he received the summons and complaint. Yes.
Okay, so as long as an employee signs of a corporation, signs for a copy of a summons and complaint, that's enough to get discovery on whether or not there's actual notice.
Well, in addition to that, he signed on other occasions for at least one other occasion for a certified mail. So he's a person in authority to
What
accept
was
the
that?
mail.
What was that?
That was after the summons expired. When I
Where in the
sent
court rules
the,
does it say that it's enough to serve somebody who's authorized to accept mail?
all I can say is I have proof that this corporation received the summons and complaint signed by an employee of this corporation. And the court rule says if they received enough information to inform them of the action within the time provided in these rules for service, an action shall not be dismissed. And that's a mandatory court rule that's been in effect for 40 years. What
Understand your
the other thing that he signed for was the I think it was the motion for default judgment. And that was in November of 2021.
Any other questions? I think we've gone over
No, I'm
this
sorry.
enough so
I
that,
just want to be accurate.
let me finish.
Sorry.
I think we've gone over it enough. I'm not hearing anything that's in direct rebuttal to what she said that we haven't already heard. So we're going to deem the matter to be submitted.
Thank you, Your Honors.
Thank you, Your Honor.
That brings up item number 23, case number 371132, Weatherspoon versus Podolin. There are numerous parties endorsed on this. Good afternoon.
Yes, I guess it is afternoon. Good afternoon. May it please the court, Steve Hicks, on behalf of the plaintiff appellant Tamika Weatherspoon. As the court knows, this is uninsured motorist claim against Member Select. There is also an underlying negligence claim against Podolin here. The trial court ruling in this case is what's being challenged. Basically, the trial court concluded that there was no admissible evidence in this case that that Podolin and the vehicle she owned was uninsured. We're claiming that's error because, and I think the court has probably dealt with this issue before. It's sort of that distinction between what is substantively admissible and what is when something is admissible in form. It needs only to be substantively admissible. It doesn't need to be admissible in form at the summary disposition stage. So what is the evidence we're talking about in this case? The evidence that we're talking about stems primarily from the police report that was submitted. And in 3 different locations, there's an indication that there isn't any insurance on this vehicle.
Let me ask you, how's that coming in? How's that police report make its way into evidence?
At trial?
At any time.
I
Yeah.
found this on the web.
No, found it on the web. At any time,
Well-
how does this,
Typically, I mean,
not typically, in this particular case, how does this evidence
they're
come
gonna
in?
put the officer on the stand. They basically use the police report.
But you don't
for
have
short-
the officer's testimony, correct?
Correct, and that's what the trial
So-
court.
So
had
let me
issue with.
finish. So the police report is hearsay. So what your client or what trial counsel presented to the court was hearsay, right?
There's a couple exceptions that apply with police reports. The most commonly cited one is a business record exception. It is something that is routinely taken down in these circumstances.
Police report may come in, but how does this statement that
Sure.
I don't have insurance come in? That's all I'm worried about.
Okay, yeah. So you're talking about the fact that there are 2 levels of hearsay here. So the police report, I thought you were asking about the police report. The second level of hearsay would be that this is a statement made there's 3 different notations on the police report. Insurance company, none, insurance policy, none. And then there's a citation that's issued for no insurance.
Mr. Whiteside.
Yeah.
Issued to Mr. Whiteside, yes, because he's the operator of the vehicle along with the other citations that he got. But to get to your question, Judge Borello, with regard to how does the statement come in? I think it's clear that it's an admission by a party opponent.
But who's
in
it
this
being
case.
offered against?
It's, well, that I think is an interesting question because
It's a very interesting.
well, they would argue that, hey, we're member select. We are an insurance company. Podolin is different from us. But what really is an uninsured motorist claim? An uninsured motorist claim, you have to prove certain things that you would prove against Podolin in order to win your case against the insurance company. Essentially, it is subsumed into the uninsured motorist claim. So I would argue that it is being offered against them in this situation,
But
because
it's not their admission. You need your own admission to be offered against you. And I know, I mean, they cited case law to that effect. I didn't see any in your brief. Do you have any case law to support your theory?
that is offered against
That
them.
this is the admission of a party opponent exception allows the admission of
I didn't,
Podolin to be offered against member select.
I did not find a case in the context of an uninsured motorist claim like this one. And I think it is fundamentally a different type of claim. And in terms of the case law that they cited, I don't believe any of their cases went to that as well. I would say this is.
Well, it's just the legal proposition they're offering. And I guess I'm looking for something similar from you that indicates under any circumstance, we don't have, we don't have, the party being the one making the admission and also being the one who is being offered against. We don't also have any other sort of relationship recognized.
I guess the argument I'm making is that indirectly it is being offered against them because you can't prove up an uninsured motorist claim.
Right, but I know it's being offered against them, but it's not their statement. So it has to be on both. I know you want to use it against member select. I get that. But but it's still not their own statement that you're using against them. But I think which is what the hearsay rule addresses.
I think the question at this stage, and I can't think of any case where I've spent this much time thinking about hearsay in the context of a summary disposition motion. The fundamental question really comes down to admissible in form versus substantive admissibility. Here, sure, there are these hearsay rules that need to be looked at when you get to trial. But we don't have to establish conclusive evidence that they were uninsured at this stage of the game. We simply have to establish that there's a question of fact on that. And the way we've done it is through the police report and also and let's not forget, there was also an affidavit from the client in which she said that Podolin came up to her afterwards.
That has the same hearsay issue, right?
I think it does have the same hearsay issue because it's Podolin, I can't say your name correctly, offering the statement. But it is an admission on her part. It certainly works against her interests to be uninsured in this case. It opens her up to the possibility.
It would be admissible against her, right?
I think it's
Podolin state. I mean, your client's.
I think it's
account of what Podolin said would be admissible against Ms. Podolin.
I think it's admissible evidence in this case, and I think that's all I have to establish at the summary disposition stage is that
It has to be plausibly admissible.
Correct. I think that's arguably even in lower standard. It just has to be
I don't think it's plausibly admissible because the rule specifically states it's got to be offered against that party. And there are no statements that have been put forward that were made by that party, made by the insurance company. So I think you have a real problem.
Well, I'm not going to belabor the point with the court. I mean, there are other potential hearsay exceptions that could play in. Well, in thinking about this and looking at their response brief, it does occur to me that Podolin's real cagey in her answers to our request for admission. We basically had asked her to admit the vehicle's uninsured, and she says, "Well, after diligent search and inquiry, I can neither admit nor deny that." Effectively, what she's saying in that circumstance is she's saying, I don't have any memory on this subject matter. that can make her an unavailable witness if you don't have memory of something.
Counsel, you didn't brief us on this. Is that right?
That is not a point of brief. You're correct. You're correct. I thought we were on strong ground on the D2 argument. So I guess just to bring it to sort of a conclusion is the question here is really what the standard of evidence is going to be at the summary disposition stage. Are we going to try the case at that stage? Are we going to have to walk through hearsay exceptions and have those hearings to do that? Or are we going to be able to look at evidence that's routinely used in these situations as a shorthand for what the officer is going to say at trial, for what, Podolin would be deposed as well, for what she's going to say at trial. And I would say that conflicts, it fundamentally conflicts with what our courts have said about what should be admissible at this stage. And it's really just the substance, the content that should come in. The form of it should not be this court's consideration. I think that would be a very different ruling than what I've seen.
So I can bring a motion for summary disposition and say that I understand Judge Mariani told Judge Trebilcock, who told Judge whoever, blah, 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 and the court would not be at summary disposition would not be able to say, boy, I don't think that's admissible evidence that you put in your affidavit. We're just going to accept it as true. Is that what you're saying that our statement is?
Yeah, I don't know that I followed the hypothetical.
In essence,
There are a
I
number
can
of
just
different
put forth
stages
any
to it.
evidence, be it hearsay or whatever, and the court has no obligation to determine its admissibility in a summary disposition.
No, the court has stated, and then you stated yourself, plausible admissibility is the standard. I think I've shown plausible admissibility. I don't know that the trial court would definitively view the rule the way Judge Mariani and yourself seem to be viewing it. I think it's broader than that. It's an admission of party opponent. But if the court doesn't agree with me on that, you don't agree with me on it. So I think that's all I had, unless you have other questions.
I don't have.
All right. Thank you.
Thank you.
Good afternoon. Hi, Samantha McLeod on behalf of the Applees. Okay. I'm sorry, I'm typically soft-spoken, so I will project my voice. Samantha McLeod on behalf of the Applees. Tim Deemer is also here on behalf of the Applees. I'm going to refer to the Applees as member select through this, and I'm going to be brief. And any points that I do not address, I will rely on our brief.
Do you think we didn't state your case well enough for you, or?
No, I do not think that at all.
Is there anything else that you can add to brother counsel's statements? He's in essence arguing that we're looking with a too fine a tooth comb to, in the vernacular, at the evidence. What's your response to that argument?
I agree with the court's questions and interpretations of the evidence that was submitted and analyzing it against the rules of evidence. I think one point that I would want to make, just to highlight and bolster what this court has already commented on, is Mr. Hicks has commented on the substance of the evidence that is admissible, and the substance, while it does not have to be in the true form that is presented to the jury at trial, there still needs to be something to the substance. And specifically with the police report, the issue is that we don't have the source of the information. So that's dealing with that second layer of hearsay that isn't addressed. And a similar issue is with the affidavit, as Judge Mariani pointed out, that the statement is against Ms. Podolin, not member select.
There's nothing in the record to indicate that they had insurance, right? I mean, I don't think we could be blind to the challenge of proving a negative.
Mm-hmm.
And as far as I know, there's no record evidence that there was insurance. Is that accurate?
That is correct.
And then we have, things banging around here. So everything you look at indicates not. Is that accurate? And it's just whether it's whether it's been presented well enough to get them over the hurdle. Or tell me why I'm wrong about that.
That is not member select's burden. That is Ms. Weatherspoon's burden. She
Well, to prove
had-
ultimately, but it's your motion.
yes, yes.
So we have to, the
Yes.
evidence viewed in the light most favorable to
Yep.
the plaintiff doesn't create a factual question.
Yep.
Right.
And there was no evidence that was presented stating the otherwise, that there was insurance that was present or not insurance. So based on that information that was available at the time of the motion for summary disposition, member select's motion was appropriate because there was no evidence in the record. And Ms. Weatherspoon had ample opportunity to engage in discovery to determine this information. Ms. Poldolan was never deposed. The officer that authored the report was never deposed. There was no affidavit from the officer. So there's nothing in the record to confirm that there is an uninsured motorist claim.
If the officer had provided an affidavit that said, I filled out this form after asking these questions, do you have insurance? Do you have a copy of it? And the form said no, would that be enough?
Could you restate the question?
If there was an affidavit from the police officer who took the report,
Mhm.
would that be sufficient?
The affidavit would need to identify the source of where that information came from with respect to the insurance. So that information would need to be identified. There's no further questions. I will
I
rest on
don't
a written
think
brief.
so.
Okay,
Fairly straightforward. Thank you very much.
amazing. Thank you all so much.
Rebuttal.
I just have one point on rebuttal. Response to your question, Judge Trivelcock. The question that you just asked counsel, I think that would be the same hearsay problem. If that's where the court ends up, it doesn't matter that you get an affidavit from the officer saying Podolin told me this. You
Well, I mean, you could say
you
I
still
asked-
got that second level. So
I mean, not if it's based on the officer's personal observations, right? I think we know that. So if, I guess, I'm not sure, would you say it's a hearsay problem? The officer said, I reported to the scene, I requested insurance information, none was provided. I entered the form accordingly. Would that all be admissible?
I think the way they would answer the question is that no, it certainly wouldn't be because of the D2 problems, if I understand the question.
Well, what I've just said it doesn't include any statements from anybody else. It's just the officer's investigation. Like, here's what I did.
Here's what I did. Here's the investigation that I
I
did.
requested, I arrived, I requested insurance information.
Sure, I found an accident.
None was provided.
Yeah.
I completed the form according, whether
Yeah,
that.
I think presumably they might argue that it's still a statement when none is provided, that is somehow a statement. But if Podolin didn't say anything, if he asked for it and there's no response, I mean, I guess arguably you don't have a statement. But that's the level of nuance I think we get into if we get on that path. So that's all I have. Thank you.
Thank you.
Thank you both very much. The matter will be submitted. Item number 24, case number 374311, McClellan versus McClellan. Nobody's endorsed on that matter. That matter will be submitted on briefs. That concludes the second day of our call. We are adjourned.